Welcome to Diplock Solicitor's Guide on how to discontinue a civil claim.
There are a number of reasons why somebody would consider doing this. Perhaps settlement's already been reached, or maybe the circumstances have materially changed. But invariably, quite often, the reason for this is when a non-legally qualified person has started these proceedings and has created a fatal flaw somewhere along the way. Perhaps they have not filed the claim correctly, perhaps they haven't served it on the parties correctly, or perhaps the particulars of claim, the actual reason why the claim is being made in the first place, has not been clearly or adequately particularized. Whatever the reason, if a claimant decides to cease a claim they have already brought before the court, they will be expected to cover the defendant's costs to date. So this will be the cost the defendant has incurred from the start of your claim up until the point of discontinuance. If you are a claimant who seeks to discontinue a civil claim you have started, the number one document you need to reference is Part 38 of the Civil Procedure Rules, which I will link in the description to this video. This part covers discontinuance in its entirety and will contain all the information you need to actually discontinue your claim. In practice, the most common way to discontinue a claim will be to complete the form N279, which I will link in the description of this video. If you have completed the form, it must be filed on the court that is hearing the claim and also any other party which has an interest, which is essentially the defendants. As mentioned earlier, you will have an expectation that you will pay the defendant's costs to date. The only reason that this would be not the case is if the reason for the discontinuance or the reason for the civil claim starting in the first place is some form of unreasonable conduct on behalf of the defendant. What will be taken as unreasonable behaviour really depends on the circumstances of the case, but usually if the defendant has failed to adhere to the civil procedure rules or the pre-action protocol, this can be set out as a reason for why the civil claim was brought about in the first place. Without these kinds of arguments clearly based in law, you will be expected to pay the defendant's costs. We strongly recommend taking independent legal advice before initiating any civil claim in order to avoid any kind of costly errors which will end up in the claim failing and you having to cover the costs of the other side. Most judges who work in UK courts are highly sympathetic and helpful to litigants in person. In other words, people who are non-legally qualified who start claims do have a lot of sympathy from the court. However, the judge will have no discretion to overlook or ignore mistakes that are required by law. As stated earlier in the video, this includes service, this includes filing, and this includes particularizing the claim. If you do require independent legal advice in respect of a civil claim, including for discontinuing a claim, please feel free to contact us today. Our contact details will be in the description of this video. We hope you found this video helpful, and like we say, if you do have any questions, please feel free to contact us. We would also be very grateful if you could like the video and subscribe for weekly legal videos.